Justice Barrett?
How can you disagree with that in light of the stipulations that Justice Gorsuch reviewed with you? Because if it's speech, you know, as the stipulations Justice Gorsuch read did, and she has to say it, why isn't it compelled speech?
Because on the stipulations and where we are here, the company would refuse to provide the same identical speech to a customer solely because of who they are. And if the company is going to provide speech, already said they're going to do it. The website, I think it was the colloquy with Your Honor, Justice Barrett, where someone comes in and says, I want the exact same website as you gave to my friends. And the company says, no, I will not provide that to you. And the only reason is because of who you are. That's not compelled speech. Certainly there are some circumstances where there may be more of this, you know, tell the story, et cetera, but the company can choose to determine the services that it wants. Here it is chosen to say that I will not provide the exact same website for one couple that I would for another solely based on the identity of the couple.
Okay, I want to give you a hypothetical that doesn't rely on disagreement, philosophical or otherwise, with speech, but just a desire to promote a different kind of speech. So let's say a newspaper is running, as many newspapers do, runs marriage announcements. And so, you know, the New York Times says that such announcements, which it picks, have to satisfy its normal editorial standards. Let's just say that the newspaper for Gay Pride Month decides that it's going to run to promote and recognize same-sex marriage, only same-sex marriage announcements. Turns away heterosexual announcements, not because it disparages or disagrees with opposite-sex unions, but because it's trying to promote something else. Can it do that? That's a protected characteristic under the law.
Well, that's a hard hypothetical because normally the marriage announcements are considered to be a public accommodation, but your hypothetical introduces a layer of editorial discretion.
Well, you can't run every marriage announcement that comes. There would be too many. So you're necessarily going to pick and choose, just like every business is going to have to pick and choose based on resources.
Well, and I think, but in that circumstances, if the sole basis for picking and choosing is a protected characteristic, the New York Times couldn't say that we're going to have this month, we're just going to run opposite-sex weddings. Next month, we're just going to run white people weddings. Next month, we're just going to run.
So for Gay Pride Month, a newspaper can't choose to try to celebrate that and communicate a message by running only gay marriage announcements?
Well, again, I think the answer is no, but that's an unusual case because a newspaper obviously typically has great discretion.
Well, it might be an unusual case, but the problem, and what a lot of the hypotheticals are getting at, is however we decide this case obviously applies to others. And what if we say it's not the New York Times, but what if we say that it's a gay rights group that wants to publish gay rights announcements online all year round, not just for Gay Pride Month, because it wants to celebrate love in that community. And so it publishes only same-sex marriage announcements and turns away opposite sex. Can the gay rights organization do that?
Well, I think that's very unlikely to be a public accommodation, so the answer is likely yes.
Well, they're paid. Why? I mean, they're paid. I mean, they craft these for, and it's a business, it's a commercial enterprise, but they craft these announcements for the gay community.
So I guess who crafts the announcement? I thought
it's a gay rights enterprise. It's a group run by, you know, people who are interested in promoting gay rights, and it's a forum to celebrate gay marriage. They charge, you make money, and you run marriage announcements that have our story, et cetera. But it's done specifically to celebrate love in that community. Can they turn away opposite sex marriage announcements? In
this unusual hypothetical, assuming they're a public accommodation, they cannot turn away announcements based on a protected characteristic. So they couldn't turn away opposite-sex announcements or interracial marriages. I think if they're a public accommodation, but I think
so they can be compelled to. It's not that they have anything against opposite-sex unions, but they can be compelled to give their, you know, web space to those announcements, even though it's not consistent with the message of their organization.
Again, assuming they were a public accommodation and opening themselves to the public,
assuming they're
yes,
public accommodation.
They can do that. But I think what makes the hypothetical difficult is that assumption likely does not apply to most organizations like that.
But it seems like you can't get out of everything by defining public accommodation narrowly or broadly, depending on it. I mean, you agree that in Hurley, the parade was a public accommodation, as we held? Because Hurley is your hardest case, right?
It's a difficult case, but we are different than Hurley, and I'm happy to talk about why. But the public accommodation law was applied to the parade in Hurley, and the court said that was, because of the peculiar circumstances there, it was inappropriate. But importantly, in Hurley, everyone could march in the parade. The only issue was who could carry the banner in the parade, and in this case, people can't march in the parade. The company is turning away people for their products based solely on who they are, and that's the big difference from here in Hurley.
Thank you.